Good morning, managerial personnel of Trinidad and Tobago. This is your humble servant, Gabriel Ace of the Employers Consultative Association, coming to talk to you again on a very interesting topic, the managing of grievance handling in industrial relations in Trinidad and Tobago. Managing the handling of grievances calls for certain fundamental factors such as the laying down of a grievance procedure, very important, having knowledge of the principles and practices of good industrial relations. 2. 3. Knowing both the rights of management and employees in particular. And 4. Having the ability and willingness to listen rather than to hear. In all workplaces, as you will know, grievances will come about. Employees always have grievances. And if they are not managed, controlled, attended to, or nipped in the bud, can become extremely costly to management. Now, not every complaint is a grievance, and workers do have sometimes imaginable grievances. So in order to have them not to waste your precious time, you must understand from an industrial relation point of view what is a grievance. A grievance, as you know, is the violation of a contract between the worker or workers' union and the employer, and any laid down principles and practices of good industrial relations in Trinidad and Tobago. As a manager or human resource manager, or for that matter, an industrial relation officer as well as a supervisor, it is imperative that you know the sources from which these principles and practices originate, namely the International Labour Organization, ILO, labor laws of the country, practices, natural justices. As managerial personnel, you ought to know that Convention 87 gives every worker in Trinidad and Tobago the right to join or not to join an organization of his choice. You ought to know that Convention 158 compels you to give a solid reason to the worker whenever you are terminating the services of the worker, and do not depend on giving him notice only before doing so. You ought to know that the Convention 100 prevents you from discriminating against either sex performing the same jobs in respect of pay and status. You ought to know at least the rudiments of the Minimum Wage Act, the Maternity Act, the Severance Pay Benefit Act, and the Industrial Relations Act, as well as the Occupational Health and Safety Act, which has recently been passed. Where natural justices are concerned, it is essential to know, Mr. Manager, that a person is innocent until proven guilty. Therefore, opportunity to be heard must be carried out. It is also necessary to give the benefit of the doubt to the accused. And whenever you are going to charge a worker, always charge him or her with misconduct. You can never go wrong. Practices in industrial relations tend to dominate the relationships between management and labor in Trinidad and Tobago. When we refer to practices, we are not talking about best practices as is involved in human resource management. We are talking about understanding ancient habits, informal and formal relations, and procedures that have been agreed to between labor and management. Examples are the 2-day sick leave that workers claim almost every day. In addition to the above, you ought to know, Mr. Employer, that the progressive form of discipline, that is warning orally, warning in writing, suspension and dismissal. There are many more principles and practices to which we can refer, but we are limited by time. When handling grievance management, should use Dr. Hepston's Stoll method, which is mapping the problem. That is, knowing what you are trying to achieve, seeing the other person's point of view, empathizing, walking the shoe of the other person, supporting your case, and then presenting your case. Ladies and gentlemen, I have tried my best to indicate to you what managing the grievance handle is all about. If you were to put these things in practice, you will never go wrong, and you will never be afraid of any third party. Thank you very much.